A former Ohio middle school teacher is headed for a very different day-to-day environment. She is going to prison. Stefanie Erin Kellenberger admitted to grooming a young teen girl for sex, and her scheming went on for years. But now that she's entered a guilty plea, we are taking a look at her sentencing and whether the punishment fits the crime. And we're going to break it down with a former Ohio Deputy Attorney General. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Stefanie Erin Kellenberger did not have a good birthday this year. No, instead of celebrating with family and friends just one day before she turned 41, she was in a Richland, Ohio courtroom to learn her fate for sexually abusing a teenager. The sixth grade teacher's birthday was on Tuesday, October 7th, according to the Richland source, and the outlet reports that she taught English and language arts in the Shelby City School District since 2015. But back in August, Kellenberger entered a guilty plea to a staggering 21 felony counts, which were filed against her in Richland County last year. The bailiff for Judge Brent Robinson's courtroom told the Richland source that she admitted to 4 counts of sexual battery and 17 counts of unlawful sexual conduct with a minor. And the victim in all of this? The teenage babysitter of Kellenberger's own daughter. This is according to the New York Post. So to discuss how we got here, to discuss the investigation before Kellenberger was officially sentenced, I want to welcome back onto Sidebar former prosecutor and Ohio Deputy Attorney General Mark Weaver. Thank you so much for coming on. It's really good to see you. We are seeing more and more of these cases involving teachers preying on young people, preying on students. How much experience do you have with these cases? Is it more common now? Are you seeing it more and more?
It feels more common. I do have experience, sadly. I've prosecuted cases like this. Perhaps it's more common because the ability of teachers and students to interact outside the classroom is just different than it was decades ago. Social media is so ubiquitous with young people. Some teachers share their social media handle or their phone number with students, which I think is a red flag as a parent myself. But the ability of teacher and student to interact outside the classroom is greater than it ever has been before. And that often leads to good things, like maybe encouraging you for your track meet or for going for that Eagle Scout certification, but also has the potential for some bad things like grooming and sexual conduct.
We'll get more into this plea deal, but were you surprised to hear her pleading guilty to 21 counts to avoid a trial in a case like this? Or does it suggest to you she didn't have much of a defense?
She didn't have much of a defense, but there was an agreed recommended sentence. We'll talk about that in a moment. I think there may be some concerns with this victim going a little bit sideways, as we say in the prosecution business. But let's get into the sentence. If you want to set it up, I'm happy to talk to you about how I think we got there.
That's a good point. Okay, so here's what we know. According to the Richland source, Shelby City Superintendent Michael Browning got a call that allegations had been made against a middle school teacher. And Kellenberger was put on administrative leave in February of 2024. The superintendent sent her a letter stating, "This letter is to inform you that you are being placed on paid administrative leave effective today, Wednesday, February 28, 2024, pending further investigation of certain matters related to your employment. During this period of administrative leave, you are assigned to your home during school hours. During this time, you must be available by telephone, available to perform work if requested to do so, and available to cooperate with the Board of Education's investigation." She was also banned from school events. The letter says, until further written notice, you are not to attend school functions, or engage in school-related extracurricular activities, whether on Shelby City School District property or any other location. You are also prohibited from accessing school equipment, computers, or services. During this period of administrative leave, you are cautioned not to communicate in any matter with your students, their parents, or other individuals who could be witnesses to the pending investigation. But then the superintendent sent another letter months later letting her know that they needed to bring in a new teacher so they had enough educators to go around. In May of 2024, Superintendent Browning wrote, "While you're still on paid administrative leave, the district must begin planning for the next school year. There is uncertainty about when the investigation will be completed, when the school can begin its Title IX investigation, and how long these processes will take. Because of the uncertainty, you are notified that the 6th grade teaching position you currently hold will be filled to ensure continuity and allow teachers to collaborate over the summer months as they plan for the next school year. And the superintendent assured her, or seemingly assured her, that she still had a job, said that she could come to the school in June to collect any personal belongings. Now, let's start right there, Mark. Is that a typical response? Some would say, my gosh, based on these allegations, why wasn't she just fired? Why put her on administrative leave?
Putting a teacher on administrative leave is a typical response. Remember, in at least Ohio, these are unionized teachers, so they have contract rights under the collective bargaining agreement. But I will say this, many months of waiting, that's not typical. I've come alongside, not as a prosecutor, but as a private attorney, I've come alongside school districts who have allegations against teachers of a sexual nature. The moment there's any credible evidence that this illegal behavior has occurred, the school district can take action, notify the employee that they're going to terminate them. I was surprised at how long it took for them to get around to disciplining this teacher. Many, many months is not typical.
By the way, you know why we're able to bring you stories like this? It's not only because of the amazing support from you all out there, but also from our incredible sponsor, Morgan & Morgan, America's largest injury law firm, a firm with over 1,000 attorneys. You know why they're so big? Because they win a lot. They have recovered over $25 billion for more than 500,000 clients. In the past few months, a client in Florida received $12 million after the insurance company offered just $350,000. Out in Pennsylvania, a client was awarded $26 million. That is 40 times the insurer's $650,000 offer. Another client in Pennsylvania received $29 million after being offered only $500,000. And even if you think your case isn't worth millions of dollars, why not start a claim and fight for what you deserve? Morgan & Morgan makes it so simple. You can start a claim from your phone in just 8 clicks. So if you're injured, you can easily start a claim at forthepeople.com/LC Sidebar by clicking the link below or scanning the QR code on screen. Well, let me ask you this. Have you seen a situation before where someone is accused of wrongdoing in a school, right? Sexually abusing a student, let's say. The case is either dropped, the person is found not guilty, and then they can remain a teacher at that school?
I've not worked on a case like that, but I'm sure it's happened. We all know there are some small number of false allegations. This is going to come down to what did the superintendent and school board know from the prosecutor? If the Richland County prosecutor kept it very close to the vest and didn't offer any evidence about what they were uncovering, then it might be understandable that it's going to take several months. But if the superintendent and the school board had any information that this may be happening, there's no good reason why you continue to pay this person, because administrative leave is paid leave. There's no good reason to keep them on for months if they had credible evidence that there was sexual conduct between this teacher and a 13-year-old. You said a teenager earlier. That's true. A 13-year-old child.
So the Richland source reports that Kellenberger was indicted on 21 felony counts on September 26, that she resigned from her teaching position 2 weeks later. The Mansfield police, they investigated these allegations because the incidents occurred within the city limits at Kellenberger's home. And prosecutors say that she started grooming a young girl who had also been, as we mentioned, her family's babysitter, so from the time she was 13 until she turned 16. That Kellenberger started having sex with this girl at her home when she was 14 years old. This is according to prosecutors. And on August 1st, Kellenberger appeared in court to change her plea from not guilty to guilty. According to reporting from the New York Post, prosecutors gave her 2 options when it came to her punishment. She could serve 12 years, flat prison time, or 15 years with the possibility of release after 10 years if she behaved herself behind bars. She chose the second option, and the judge took that recommendation into consideration. Now, after the plea hearing, a pre-sentencing investigation got underway. Mark, let's go back to the conversation we had before about a plea deal. Is that typical to offer 2 options to a defendant here? And again, going back to the idea of pleading guilty to 21 counts, now we've added a little bit more understanding here and a little more context. What are you taking away from it?
As a prosecutor, when I have good evidence, I have more leverage to get a better deal with the defense counsel. So I have presented defense counsel with 2 different options, but they're almost always in the same range from one another, or they're helping me get to an outcome that I think will be just for the state of Ohio, which is who I represent, and the victim, who I don't represent, but I want to consult with. In this case, there's some indication to believe that the victim did not want a serious sentence for this sex offender. That could have been a problem had this gone to trial, because the jury may have picked up on that.
Mentioned defense before. So according to Kellenberger's attorney, James Meyer III, quote, consent was never an issue. It's an age thing. What does that mean?
Well, in Ohio, when a teacher is having sex with a student, there's two different charges that can be brought. They're not rape charges. One is called sexual battery, third-degree felony, and the other one is unlawful sexual conduct with a minor, also a third-degree felony. The elements are slightly different. In unlawful sexual conduct with a minor, that's an age thing. That's an adult having sex with a child. In sexual battery, it's a power thing. You're a teacher, you're a coach, you're a parent, you're in some authority figure over the person you're having sex with who's underage. And that is less an age thing, because the elements are student teacher, not adult child.
But by the way, I mentioned after she pled guilty, there was this pre-sentencing investigation. What is that? What is that investigation? Who do investigators talk to? How does it work?
In almost all felony cases, before a judge will enter a sentence, unless it's a mandatory sentence where the judge has absolutely no authority and must enter the mandatory sentence, the judge will ask the probation department, the adult probation department, to interview the victim, interview the defendant, interview the employer and the family of the defendant, and try to give the judge a sense of who this person is. And there's good information for the defense and bad information in there, aggravating and mitigating. It's almost like a little book report, if you will, on the defendant. And the probation department will sometimes make a recommendation. More typically, they're just giving the judge the facts, who can make a decision about what sentencing is. So it's called a PSI for short, pre-sentencing investigation. We, as the prosecutor, get to review it usually the day of the sentencing. It's not a public record, but it's something the prosecutor and the defense counsel are allowed to look at. And it informs the judge's thinking ahead of the sentencing hearing, where other people can then testify in open court.
I imagine it also takes into consideration the victim and also maybe interviewing the victim. The reason I say that is because Richland County Prosecutor Jody Schumacher told the Richland source, quote, the minor, the student, was blaming herself. Because of that, she did not necessarily want to see the defendant, in the victim's words, ruin her for the rest of her life. She did not want her to go to prison for the rest of her life. And in fact, according to Schumacher, the victim apparently wanted Kellenberger to only get 3 years in prison. Now, the judge didn't agree with that, thought it was too short of a sentence. We'll talk about what the judge imposed. Mark, you mentioned before that one of the considerations here going into trial might have been the victim here. How much, let's start here, how much does a victim's wishes play into a judge's decision in cases like this when it comes to sentencing?
Prosecutors and judges should listen to victims. In this case, this now an adult was a child, but this person has gone through a very traumatic time. And as a prosecutor, I always care about what the victim has to say. In fact, in Ohio, at least, the state constitution requires that victims have a voice in every substantive hearing or trial that happens in their case. But I often had to remind victims that this is not their case. This is the state of Ohio versus, not you. You may have a civil action against them. You want to sue them for battery or something else, then it's your case. You get to decide the outcome to the extent that you can. But in a criminal case, I represent 11.5 million people, the state of Ohio, and I've got to make a decision that's best for them. And what's so sad about this case, Jesse, to me, is the grooming and the sexual power over this child who's now an adult still impacts this person's thinking today, where this victim thinks that somehow she's at fault and that the predator who preyed on her perhaps ought to not go to prison for too long. I've seen that before, not a lot, but I've seen that before, and it just shows you how devious and how insidious this power position is of predator over victim.
No, 100%. And I do wonder, though, does it affect the prosecutor's decision to offer a plea, to take this to trial? Do you think when you're listening to this, and we don't know everything the victim would have testified to or what she was thinking, but it is quite a statement for the prosecutor to say that this victim was blaming herself, wanted limited prison time, I think it does suggest what may have complicated this victim's testimony.
Yeah, I mean, I go to prosecutors' conferences. Sometimes I speak there. Sometimes I'm just a participant. And when we get together, we talk about things like this. And we have a little fun with juries. I'll clean up the language, but we say things like juries can be funny, right? You never quite know what a juror's going to think. And when you're the prosecutor, you have to prove beyond a reasonable doubt, not only all the elements of every charge, but you must get a unanimous jury to come alongside with you. You must get all of them. And my fear sometimes is when my victim doesn't feel strongly about the case, that when I call that victim to the stand, either on my direct examination or on the defense counsel's cross-examination, there's going to be this hesitancy about whether or not this punishment is appropriate, whether this was really a crime. And you're never going to convince 12 jurors that this was not a crime. But one juror in his or her mind could go, you know what? If the victim doesn't think this was a big deal, why should I? That's enough to hang a jury.
Now, the prosecutor's office said that the most important thing that the victim wanted was for Kellenberger's teaching license to be permanently revoked, which our understanding was it was. Is that only in Ohio, Mark, or would it be nationwide?
No, that's only in Ohio, but if this person were to go apply for a teaching job elsewhere, that state would get the records from Ohio, and no prudent school district would hire this person after this history. But this is a key part of it. I had prosecution once against a teacher who was not sexually acting out, but was physically aggressive and abusing students in a way that was harmful and potentially harmful. And in the middle of the trial, the defense lawyer wanted to settle. And I wasn't interested in sending this teacher to prison, but I did want to make sure he never taught again. Mm-hmm. So part of my resolution was that this person would withdraw his teaching license and agree to never teach again, because obviously we want justice for this crime, but we also want to prevent any future crimes. Now,
talking about Kellenberger, she apologized to the teen victim in a statement at her sentencing hearing on October 6th. Here's what she had to say, according to the Richland source. I know that during this time you were just a child and I was an adult in a position of trust. I'm responsible for everything that happened between us. I put you in a position that no 14 or 15-year-old should ever have to be in. I'm so sorry for all of the emotional pain and hurt that I've caused you. I hope that my guilty pleas and this sentence will provide some degree of closure for you as you move on with your life. And Kellenberger also apologized to her family, especially her daughter, since she fully accepted the consequences of her actions. And the defense and the prosecution, they agreed to that 15-year sentence that I mentioned before. And while Judge Robinson wasn't required to accept that recommendation, he stuck with it. Now, Kellenberger is required to register as a Tier 3 sex offender. After she gets out of prison, she has to re-register every 90 days for the rest of her life. Mark, were you surprised that the judge agreed to the 15 years here? And we know that this is something Kellenberger agreed to because there's a possibility she could get out earlier. So A, what do you think of the judge accepting that accepting that sentence? And B, can she get out earlier?
She can get out earlier. She can get out if she's a model inmate and follows all the judge's rules. You've got savvy viewers here at Law&Crime. They may know this, but for those who don't, prosecutors and defense counsel will often go to the judge back in chambers, not on the record, and say, Judge, we're thinking about doing this. Can we take your temperature on whether this sentence range is going to be okay with you? I don't know that happened in that case, but I know I've done it many times, and that will give the litigators a sense of what the judge may be willing to do. The judge is smart enough to know that if the prosecution is willing to settle the case for a lesser amount of years than might possibly be given, the judge knows something's up with the case. Sometimes it's a due process problem. Sometimes it's an evidentiary problem. In this case, it's our victim doesn't think this is a big deal problem. And I don't want to be too tough on the prosecutor. You don't want to re-victimize the victim if you don't have to. You don't want to put a child who's now an adult on the stand to recount the most embarrassing details of their life in a room full of strangers. And you want to get the certainty of no appeal. so that that victim doesn't have to worry about the case coming back for another trial 2, 3, 4, 5 years down the road. So I understand why they did this. I think it's a fair sentence. Would I like to have seen this woman do more time? I would, but I live in the world of reality, and reality is you have to settle sometimes.
And just to focus on this idea of her being a tier 3 sex offender, what does that mean for her life and the community?
It means she won't be able to live near schools or child care centers. She will not be able to interact with children. She will have to be checking in with the sheriff's office every 90 days to make sure that they still know where she is. If she moves to another town, she will have to immediately register there. And any violation of that status is a felony in itself. I've often joked to my prosecutor friends, it's the easiest 2-witness case you could ever prosecute. Put somebody on the stand. Is she a registered sex offender? Yes. Put somebody else on the stand. Did she register with you and follow the rules? No. Your Honor, we rest our case. It's an easy felony if she violates any of that, and whatever judge who has that case will send her back to prison.
And talking about that sentence, so Richland source reports that the judge determined that each of the 21 counts that Kellenberger had faced equated to 60 months or 5 years in prison. Counts 1, 2, and 3, they're going to run consecutively, back to back. Counts 4 to 21, going to run concurrently, so at the same time as the others, and that is what gets you up to 15 years. But the judge made sure that everyone knew that Kellenberger would have to be on her absolute best behavior for the first decade of her sentence. Quote, "Don't let anybody be confused. This is a 15-year prison sentence with the hope that you come back in 10 years and you've been a model inmate. You've done everything you were supposed to do and you haven't gotten any trouble at all." Mark, that's an important statement to make by the judge.
Yes, it is. And it's difficult for prisoners to make it through, in this case, 10 years and not have any violations. The smallest little things in prison can be infractions. And so only rarely do you see somebody who has a perfect, spotless record in prison. So if the judge wants, the judge will be able to hang those extra 5 years on this woman. A lot of us would like to see that happen. The prosecutor has to live by their recommendations, so I don't know that the prosecutor would speak into it. But as somebody on the outside, as a prosecutor, I can say, I'm rooting for 15 years here.
Well, once she's released, she's going to be subject to 5 years of post-release control. This is, again, per the Richland source. She can't have any contact at all with the victim. We will see what will happen with her. But Mark Weaver, thank you so much for taking the time. Really, really appreciate it and giving your expertise on what is a very disturbing case.
Sad case indeed. Always good to be with you, Jesse. Thank you.
And that is all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll see you next time.